Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Interpretation class. Friends, today we are going to discuss another interpretation. It is called as casus omissus, means case omitted, or cause omitted. That means omitted inadvertently by mistake or omitted purposefully. Sometimes they may omit purposefully also. So, casus omissus is rectified by the common law. So, casus omissus is a Latin term which means case omitted, right? So, how cases are omitted or how the words are omitted? So, let me tell you a few incidents better for your appreciation. Normally, for preparing a GO, experts will be there. Normal people, they can't prepare the GOs. There are certain experts. While preparing the GOs, they will be leaving certain gaps. Likewise, ordinary legislators, they cannot frame laws. There are experts. No doubt these people who are only going to discuss. So the experts, they make the law. They also leave some parts gray area. Why? Because law is not 100% perfect. GO will not be 100% perfect. There may be some gray areas. They can be covered. That is the purpose of leaving certain things. So, as advocates, you may be seeing the remand reports by the police. You might have observed the police say the accused was brought to the police station, the accused was arrested, the accused was interrogated. They don't write in the active voice, they always say the passive voice. Suppose normally when an officer, investigative officer arrests the accused, he has to say, as SSO Ongole Taluk Portion, I received information, basing on information, I went to the place, arrested the accused, interrogated him, on his confession recovered something like that, we have to write. But we don't write. Why? Suppose if it is passive voice, the accuser was brought, the accuser was arrested. Then, if you want to file a private case against the particular individual, you can't file so easily. Tomorrow, the police officer say, yes, my SI or my head constable made the arrest. They can prepare the records. So that's why the loopholes are there everywhere. Right now, there is a casus omissus. That means there is a omission of particular topic or particular case. Then the judge, if the matter comes to the knowledge of the judge, what is the duty of the judge? He has to enter the matter. He cannot fold his hands and curse the person who framed the law. Here it is written, role of the judges. When a defect appears, a judge cannot fold his hands and blame the draftsman. He must work on finding the solution. He must try to find out the intention of the parliament, and he must supplement the so-called written words to give force and life to the live intention. This is what is called judge-made law. So this can be seen from the president, doctor of presidents, or from the common law. Normally they will refer to the common law. Case laws. Sangeeta Singh versus Union of India, 2005. This is allocation of dealership, IOC dealership case. Actually, the center notified, IOC notified that the persons who have got the so-called license dealerships, they should not contest or they should not bid for the same. And their relatives also should not bid for the same. Already our client Sangeeta Singh, she is having a dealership and she wanted to get the dealership in the name of her father-in-law. Because as per law, father, mother, brother, sister, they are only family members. Father-in-law is not a family member. So they wanted to take that plea. But here, normally family members, so the role of father-in-law is omitted. But the court clearly stated that the intention of the parliament, intention is to see that the new entrepreneur should come up, not the relatives of your own family. So therefore, this is clearly held that the father-in-law is not permissible to get the so-called dealership. So the casus omissus has been rectified. Second case, Union of India versus Messrs. Dharmendra Textiles, Processor and others, 2008. Here also, a causes omissions took place in section 11 11A within subclass C of the Central Excise Act 1944. Here it is very clearly stating, already I told you, strict construction of the taxing statutes. So when the mens rea of the persons who evaded the tax is found, there is no discrimination for the assessing officer. He cannot skip away. He has to award the penalty. No scope for any discretion for the assessing officer. So please remember, very clearly it is stated that the taxing statutes must be interpreted very strictly, right? So with these causes omissions is another point. Even though there is a omission, you have to rectify the same. Okay. With this, I am concluding. Thank you very much.